Good morning, everyone. First of all, I would like to thank Pharma Education for providing this opportunity, and I'm very happy to associate with this Pharma Education, and also I'm very happy to take this session. One of the most important thing is that everyone is from pharmaceutical background, right? And I am also from the pharmaceutical background, and I did my LLB from IIT Kharagpur, and also I'm a qualified patent agent from IIT. Today I'm going to discuss about the patents and designs. First thing is that significance of patents and designs with relate to the pharmaceutical industries, and then coming to the career opportunities that what we can explore. Okay. How many of you know about the patents? How many of you are aware about the patents? So I can't see the comments here. So Jyoti, can you answer that? How many have replied there? Okay. Okay. So I can see two people that they know about the pharmacy. Sorry, patents and designs, right? So let's go to the patents and designs. So I will take first into the basics of the patents. First, I would like to discuss about the intellectual properties, what exactly intellectual property rights, and also then I will go into the patents and then the significance of that, and also in light of COVID-19, how we can contribute to the patents and designs. Okay. So next slide, please. Yeah. So intellectual property rights, patents and designs are a part of intellectual property rights law. Okay, what exactly an intellectual property? So intellectual is like a mind. Okay, so the property that is generated from the mind or is created from the mind is known as intellectual property rights. So here the main importance is that, like other properties, tangible properties, like for example you're having a land or else a building, so how you would like have all the rights on the property, same way you will have the rights on your intellectual property as well. Okay, so but one here important thing is that creation of the mind, right? So here it can be created by someone's mind. For example, let's take it like two people are discussing in their lab about a vaccine which could be treated COVID-19. So a person B who doesn't involved in the manufacturing or else the research of that, he listens all the data and then he will go for the filing of that, okay, for the patent filing. So here he thefted that intellectual property from that other person. So that is the reason why we need to protect our intellectual property rights. Right? So what exactly are intellectual property rights and what are the rights that you are having on that intellectual property? First is that they are exclusive. So what do you mean by exclusive rights? So they are exclusively given to that particular person who have created that intellectual property. So, and they are territorial in nature. For example, if you are filing your patent in India, so it will be protected in India itself. Okay. And also territory to territory, the patent subject matter will be differentiated from each place. For example, there will be, how many of you know about Cas9 technology? Cas9. Fine. Gene editing. Okay, so gene editing is one technology where it can be patented in US, but it cannot be get patented in India. Okay, so there are like differences depending upon the territory to territory, what can be patented there and also what cannot be get patented. So these all things I will be dealt with the coming slide in the coming slides. Okay, and also these are having only for the limited period of time. So not like other properties. For example, if you are holding and building, so you'll have the right on that from the whole life, right? But here for the intellectual property rights, it is time is limited. So each and every intellectual property is having their own time limits. Anyone can answer that how many years that patent can be protected in India? Anyone? So I have seen that two people know about the patents, right? So little bit basic. Exactly 20 years. So 20 years it can be get protected in India. So if you look into the trademarks, it can be get only 10 years protections, right? So it depends upon the intellectual property to property, right? So for example, copyright, it takes for the protection 60 years after the life of the author. Okay, And after 20 years, it will be open to the public. This property is always open to the public. So why exactly these intellectual property rights are very important? So one is that this is a rewarding to the people who are doing research, and also it will recognize them by giving them exclusive rights. So you will get your own recognition. And then these innovations help in scientific advancements. For example, if you take the reason one person came up with the patenting in mobile technology of the touch screen. Okay, so now the competitors of that mobile technologies, they will be working on the enhancements of that. So indirectly or directly, it is pushing the technology to enhance. So this is also one of the very important crux of the intellectual property rights. Next slide, please. So there are different intellectual property rights under intellectual properties. So one is that patents, that what we are going to discuss today. The next one is design protections. This also will be dealt in 5 minutes about the designs. Okay, the patents are most important thing. Next one is copyright protections, and the next one is geographical indications, trade secrets, trademarks, and also Plant Variety Protection Act. So this all comes under the intellectual property rights in India. Okay, so now I think someone could have got the doubt that why 20 years, right? So why this limitation for the 20 years in India? So there is something called TRIPS, Trade Related Intellectual Property Rights. So all the countries of WTO should abide with the rules and regulations of the TRIPS. Okay. So in that, it had mentioned that what can be protected under the patents, what can be protected under the trademarks, what can come under the design protections, and also what are the time limits. And there is an interesting thing for this 20 years of the time limit. In the UK, when this patent system had been started, so there is an what you call Apprentice Act. Okay, so in the Apprentice Act, to gain the knowledge and experience as an apprentice, there is a 7 years of time period. Okay, so to know the knowledge of the patent, they had increased this one into 7 plus 7, 14 years. So initially the patents are protected for the 14 years. After that, when TRIPS came into the picture, so to make the uniformity among all the nations, they have increased it one more 7 years, and then they minused one. Okay, so 21 minus 1, 20 years they had done, and once they enter into the 21st year, this will be open to the public. So a normal person can able to read the invention, and then he can able to make that inventions by reading that, right? So that is the reason why this is the 20 years of limitations. And then once the 20 years is completes, the patent will be open to the public. Anyone can use that inventions, and then anyone can extract that knowledge from that inventions. Okay. So now patent, I'm going into the patents now. So we are not discussing about the copyrights, trademarks, or geographical indications, etc. So if you are anyone are interested in that particular domains, you can just contact the Pharma Education, and they will fix this seminar on that also. Fine. Now patent. So as I mentioned, that patent is an exclusive right. So this is granted in territorial in nature. Okay. So each and every territory grants that patent, and for a limited period of time. That limited period of time we have discussed it, that is for the 20 years. And then to protect your invention in different nations. For example, you are an Indian, and if you want to protect your invention in US, you need to go to the US, or else you need to file in online in the US territory. In the same way, you need to go to each and every country to file and protect your inventions, right? Then exclusive right. So what do you mean by exclusive? So these patent rights are not in positive rights. These are negative rights. Why exactly it is called as negative right? Because this is not giving you the rights. It is giving you the right to exclude others from making your invention. Am I clear? So this is a negative right. So which gives to you that you can exclude others from making or selling of your inventions. For example, now let's take it A and B are there. So two inventions, and then this is a technology improved invention, right? So for example, there is one technology that should be incorporated only in the mobile applications, and then you need to use that. So now A is having patent on that mobile, and B came up with the advancement of that invention. Now he had filed for the patent, but he cannot use that the patent of that advancement, right? So what happens is that he need to get the license from A, and then he need to go for this technology improvements. And the same way, if he want to come with the advanced versions, he need to approach B to get the patent rights of that. So this is what exactly the excluding Mr. A to use the B invention. So these are the exclusive rights that are given to the patent holders or patentees. Next slide, please. So now, as I told that, okay, the patents are in territorial in nature. For example, you want to file your patent in the US or else in 5 more other countries. So is it that like you need to go to each and every country? Because it will take so much of time, and also you need to invest so much of money, right? So there is one system called PCT, Patent Cooperation Treaty. So here what happens is that if you want to file your patent in different nations at single time with a single application and then the fee prescribed in that PCT, so you can go for the online filing and you can choose your nations. So if you want to file only in the US and UK, you can select these 2 countries and then you can file via online, right? So now, as I said that these are territorial nature, and also then there are each and every nation is having their own patentable subject matter. So patents obviously will be granted for the inventions. So this is clearly mentioned in the Patent Act. So in India, so the patents are dealt with the Indian Patent Act. Okay, this is the Patent Act. So this is completely of the intellectual property rights. Then in this you will have the Indian Patent Act 1970. So which deals with the laws related to the patents, and then definitions. For example, what exactly you called as an invention. So there is a definition clause in the Patent Act. So section 2, in that subclause M, so which says that okay, what do you call by the inventions? In the same way, there are definitions for the inventive steps, and also then there are the sections like section 3, which is the very important for filing of patent. So this says that okay, what are not patentable matters in India, right? So in India, the Patent Act 1970 deals with the laws of patents. So in here, if you look into the each and every section, it gives details of how you need to file, what is the process for preparing a patent, how you need to object a patent, how long patent can be granted. So after patent grant, what are the things that you do, and also what are the initiatives or else the interventions that government can do. So this I will cover in the next slides. So what is the role of government in patents? Okay. So these all the things will be dealt in the Indian Patent Act 1970. Clear? So now, as I told that the patents are only for the inventions. So what sort of inventions? Can all the inventions get patents? The answer is no. So the invention should be new, and also the patents can be get granted for the product as well as the process as well. So you can get a patent for the product. So and also you can get a patent for the how the process is happening to get that patented product. So that process itself can be get patented, right? So in this new product and process, you need to have inventive step, and also that should be capable of industrial application. So what exactly mean by inventive step? So the inventive step is like there should be some technical advancement. So there should be some technical advancement, or else you need to address some issues. So there is already a technology existing, but there is some problem in the technology which it couldn't able to treat that. So that there is some technological advancement of that, so which can address that issue. So this can be go for a patented, because there is some inventive step in this. One more thing, there should be either economic significance. What exactly economic significance? For example, there is a pharmaceutical product. So there, for preparing that API, so there will be different steps, right? So let's take it that okay, Dr. Reddy is following some procedural issues where they are making to end product come in 2-3 days. Okay, now the competitor Arbindo Pharmaceutical Company came up with the process where you can come up with within 1 to 3 hours only. The end product can be extracted within 1 to 3 hours. So this process is having economic significance. One, it is saving a lot of time, and also it is giving good yield. So this is called as an economic significance. Either there should be some technological advancement or else economic significance, or else there can be both. So if these two things are fit into that, this can be known as inventive step. So then it should be capable of industrial application. What exactly industrial application? So it should be either made or used in an industry. So it should be capable of making in an industry. So this is known as an capable of industrial application. So now, to an invention to get patented in India, so what are the important filters? It should be new, and also it should have an inventive step. That inventive step should be in the form of either technical advancement or else an economic significance. And also it should be a patentable subject matter in India. So each and every territory is having their own patentable subject matters. So you need to look into that patentable subject matter, and also you need to filter your inventions, whether it is coming under that patentable subject matter or not. Okay, so these inventions can be patented in India. Next slide, please. So here, as I told that, okay, there are some of the patents that cannot be get patented in India as a territorial in nature. So there is section 3 in Indian Patent Act, which deals with inventions which are not patentable. All the inventions can be patented, but these inventions cannot be get patented in India. Okay, so there are 15 categories of inventions which cannot be get patented in India. For example, for this, contrary to the public or which causes serious prejudice to the human or plant life. So for example, there is one invention which so what it takes is like it absorbs all the oxygen present in the environment. Okay, this is also a new invention, but what it is causing, so when there is no oxygen in the environment, it is causing the threat to the human life and the plant life. So such inventions cannot be get patented in India. Okay, and also discovery of scientific principles, this also cannot be get patented in India. So just the scientific principles cannot be get patented. And the mere mixings, for example, component A and component B, you mixed it, okay, and then you get some other component C, okay, just by mixing the two things, there is no any economic significance or technical advancements in that. So that mere mixings also cannot be get patented. And also arrangement and rearrangements. So here, for example, if you take an helmet, okay, so now what happens is like one person came up with the inserting a one small fan to the helmet. So he just took the miniature of the fan and he fixed in the helmet, and he said that okay, he want to go for the patent filing because he thinks that this is an innovation. But what happens is like he just arranged and rearranged the things, and then he came up with one normal thing. Okay, so just adding 1 + 1, he cannot be go for the patent. And also agricultural methods and horticulture methods. So the how you need to do agriculture, how you need to do plowing and all, okay, this all cannot be get patented. And one more important thing is that computer programs. So mostly computer programs per se means like literally they cannot be get patented. So they're protected under copyrights in India. So because all the computer programs are in what you call that in the coding language. So all the coding things will be comes under the computer programs will be under these copyrights, until unless there is some invention in that, in the hardware or software which is having a technological advancement, then they can go for the patents. Now treatment process, for example, how you need to operate a person, how you need to make stitches. So this all cannot be get patented in India. Treatment processes are not patented, but the treatment equipments can be get patented. Okay, and also new forms of known substances. For example, there is an important case in the pharmaceutical case, okay, imatinib case. So many of you know that, right? So for what this is treated, this drug, imatinib mesylate. Anyone? So this is an anti-cancer drug from the Novartis. So Novartis is having a patent on this product already for the 20 years in India. So what happens is like So when the patent term is going to end at the 18th year, the novartis have filed for extract of that. Okay. So beta form of that imitinib, they have filed for the patent again, so that they can protect for their patent for 20 more years. So this is known as evergreening of patents. So they're extending their patent terms for 20 years and 20 more years. So just simply by coming with the extracts or as the salts, esters, etc. So just the derivative of the known substance. So High Court clearly mentioned that simply for the salts or extracts, they cannot be get patented until unless they should be having therapeutic efficacy. So there should be an drastic change in the therapeutic efficacy, at least in the bioavailability of the drug, and also within how much time it can be treated. Okay, the efficacy should be at least 30% when compared to the previous drug. In that case only, this can be get protected in India, or else it will be comes under section 3D and then it will be rejected. Am I clear? So next slide, please. And in the same way, inventions that are not patentable in India are like, for example, traditional knowledges. So traditional knowledge cannot be get patented in India. For example, turmeric. So in the US and UK, they have filed for the patents in turmeric. So India had so much of invested money, and then they had researched so much to invoke that patent in US. These patents cannot be get patented in India. These turmeric inventions or as the traditional knowledges. This comes under the traditional knowledge. So there is a separate domain called as traditional knowledge. So TKDL, there is a traditional knowledge digital library in India, which maintains all the data related with the traditional knowledges, and all these traditional knowledges cannot be get patented in India or else elsewhere else. Next slide, please. Yeah. So we have discussed about the what are the patents, so what are the inventions, and also what is a patentable subject matter. So now here I would like to take you into how exactly you can go for the patent. Okay, so what are the steps that are involved in the patents? So each and everyone will have an idea, right? So at one point of time, we will get some idea and we will think that this is an unique idea and this cannot be get present anywhere else. So for this, we need to go for the prior art search. Okay, mostly for the inventions. What do you mean by prior art search? The art which is either present prior to your idea or not. So for example, today you thought about one idea and then you need to look few years back whether this idea is already existed or this technology is already existed in India or elsewhere else in the world. So when coming to the prior art, all the nations, all the territories will check into this databases of throughout globally, right? So they need to look into the prior arts whether they are existed or not. If there is prior art already existed, this cannot be get patented in India. So next, once you clear your prior art search and then you come up with the clearance report from the IP provisionals, then you can go for the drafting of your patent. So what are the steps involved in the drafting of the patent? I will discuss in the next slide. Okay, once the draft is completed, you will go for the application of your patent filing. So you need to apply your patent. So you need to fill the forms. There are forms called provisional applications and complete applications. So you need to fill the form and then you need to pay the required fee. Hello. You need to pay the required fee to the patent office. For example, if you are coming with the inventions from a Hyderabad region, okay. So you are an inventor from the Hyderabad. So where exactly you need to file a patent? There are 4 patent offices in India. One is in Chennai, Delhi, Mumbai, and Kolkata. So you need to file your patent in the appropriate offices. For example, if you are inventor from the southern part of India, you need to file in the Chennai patent office. So once you file your patent application, provisional and the complete applications, then this will go for the publication. So when the publication can be happen after expiry of the 18 months of your patent. So once the patent is published, then you will go for the examination. So you need to request the examiner for the examinations. Until and unless you request an examiner for the examinations, they won't examine your patent. So once the examination is done, they will give your examination report, and then if someone is having any oppositions on your thing after publications, so they will oppose your patent. So after that, after looking into the examination reports, oppositions, and all sort of things, the control of patent, he will either grant or reject your patent, okay, based on your draft and then how you address the issues, examination report and all. So once the patent is granted, so you need to maintain your patent for 20 years. So every year you need to pay certain amount of maintenance fee to maintain your patent. How long you need to do that? 20 years. So as we said, the term of the patent is for 20 years in India. The same thing will apply for other jurisdictions also. If you want to apply in the US or UK, the same thing. You need to apply for the provisional application, complete applications, then it will go for the publications. After that, it will go for the examinations, oppositions, pre-grant and post-grant oppositions will be there. So once your patent get granted, even that time also, someone can oppose your patent till 1 year of your grant, right? So these are the stages and the steps involved in the patent filing. Next slide, please. Yes. See, these are the steps. So the provisional application is the most important thing. So you need to fill your details in the provisional applications. So in that you need to incorporate the patentee name and who are the inventors of that, the address of the patent, and what exactly the invention is, what your invention is talking about, abstract of that, background of the inventions. This should be filed in the provisionals. In the complete applications, you need to draft your claims, and all claims should be incorporated in the complete application. Then once your complete application is filed, as I said that it will go for the publications. So after expiry of the 18 months, now here you can get a doubt. If I want to go for fast patenting system, okay, so you need your patent should be published most early. So there is an request that you can make to the controller, that request for an early publication to the controller by filling the form and also prescribed fee in the patent rules, right? So then this can be published. Once this publication is happened, at any time you can go for request for examinations. Until and unless we request for an examination, they won't go for the examination process. So once the examination is done, they will give all the detailed examination report to the patentee. For example, what are the clauses, prior arts that they found, or else if they found that okay, this cannot be get patented in India under that section C, 3C or 3B or whatever, 3D. Okay, so in that they will give all their examination questions in that. So you need to reply to that examination report within 6 months. So once you reply to the examination report, it is up to the controller or the examiner either to accept that your examination report and they can go for the grant, or else if they are not satisfied with the answers, they will call you for the hearing. So you need to go to the Chennai patent office, or else you can attend via online. So this can be done by the patent agents. Okay, so you will go for the hearing, and then you need to explain everything to the examiner about your inventions and what are the examination questions that have been raised. If the examiner is satisfied, he will grant your patent. If he is not satisfied, he won't grant your patent. Now here, if you are thinking that okay, your patent is patentable thing, but the examiner couldn't able to grant your patent, so you can challenge your thing. You can go to intellectual property appellate board, so which is a superior to the patent office. Here you can file a petition regarding your patent, and you can mention your grounds, that okay, what are the grounds that you are filed for the patent, on which grounds it had been rejected. Fine. So on this, either it will be get granted or rejected. And there are two types of oppositions in the patent filing process. One is post-grant oppositions and pre-grant oppositions. As I said that post-grant oppositions, once the patent is get granted, and then now Mr. A thought that this patent is almost similar to his patent, and then he can file for the oppositions on that until 1 year. Until 1 year, he can file for the opposition of that patent. And once the publication is done, and then someone came to know that okay, this published patent is having similar to their patent or copy of their patent, they can oppose this patent even prior to the grant of that. This is called as the pre-grant oppositions. So there are two different oppositions in patents. One is pre-grant oppositions and then post-grant oppositions. You need to fill the required form and the fee, and then you need to request the examiner that, and also you need to file to the controller that to oppose your patents. Right? Next slide, please. Yes. So now we got a patent. So what exactly that rights that a patent is having? So section 48 of Indian Patent Act deals with the rights of a patentee. So it says that, as I already mentioned, that these are the exclusive rights. So this prevents the third parties. This prevents the third parties from using, selling, making, importing in India without his consent. Okay. So without his knowledge, if someone is copying and making and marketing that product, this patentee can file a case on them for patent infringements. So he's always can stop him from making those things. If someone is doing that, he can file an infringement case. So once the infringement suit is filed, it is up to the court. Either it will give damages, or else it will destroy all the contents of that patented materials. So it is up to the injunctions that what court grants. So this is a different subject. Okay, when you go into legalities of that. Now here, as I told that this is a negative patent. Now let's take one example that, okay, Mr. A is having a patent on one, let's take the COVID vaccine, okay, and he doesn't want to give for marketing, okay, he want to keep within himself. So he can do that. It is all up to him. Either he want to go for the publications or marketing of the product or not. It is up to him. So he is the only person having all sole rights. But when coming to the medical things, in India, government can intervene in some special categories or conditions. Okay, so these are the things that I will discuss in the next slide, where exactly government can feed and how it can take the patents from patentees. Next slide, please. See, these are the defenses. So as you are having the patents, and this is an exclusive right, but still someone can use your patents. For example, government use. If government want to conduct one research, then they can use your patent without your consent. Okay. The next is research and developments. So now if you look into our pharmaceutical sector itself, now there are many patents coming up, but until 20 years, you need to wait to bring the generic version into the market, right? Now, the most of the companies like generic companies like Arabindo, Reddy's, and what they will do is like they will have their own in-house patent team. They will do their own patent searchings, and then they will keep a tap on the patents which are going to expire soon. Then they will start their research and development either like after 10 years of the patent, or else the patent which is nearer to the expiring. So before the patent expires only, they start their own research and development. So they get some amount of the patented matter, and then they will start preparing their research and developments, and then they will be get ready to launch their generic versions in market once the patent expires. Fine, am I clear? So this is called as Bolar exemption. So because there is an interesting case, Roche versus Bolar. So in that case, what happens is like Bolar company got some of the patented material from the Roche's. Okay, Roche is having a patented on that. So they got their own patented material and they started doing research and development. So Roche filed a case of infringement. It said that, okay, this is a patented material and they cannot use our patented matter because this is exclusively ours. But they went to the court and they said that this is only for the research and development and we are not going to market it. And court clearly said that until and unless if they go into the market, it cannot be comes under the infringement of a patent. So only limited amount of patented material you can export only for research and developments. Next one is parallel imports. What do you mean by parallel import? As I said that patent is territorial in nature. Mr. A is having patent in India and Mr. Z is having patent in US, right? So because each and everyone can file a patent, okay, differently. Or else Mr. A is having patent in India and he licensed his patent to Mr. B in US. So when I went to US, I purchased that patent material and then I imported to India. So I got it into India and started using. And now Mr. A cannot file an infringement suit on Mr. C, saying that, okay, he imported the patent and he didn't purchase it from me, because legally he purchased it from a person to whom he licensed. So these are known as parallel imports, right? The next one is for the government approvals. For example, research and developments and all. So to get a government approval, initially you need to start your research. So for that also, limited amount of the patented material you can use. Am I clear? Next slide, please. So these are the some defenses that they are having. So this is how an patent uh, certificate looks. So this was granted by the patent registry, so Government of India, and this is how you will have a patent number. So the application number, so which will be given when you file your patent. Okay, and then date of filing. Because why the date of filing is important? 20 years will be calculated from the date of filing, not from the date of grant of patent. So, okay, am I clear? So the 20 years count will start from the date when you file your patent, not from the date when the patent is granted. So in this, the details of the inventor, the patentees, and the invention name and everything will be incorporated in the patent letter. Next slide, please. Next slide, please. Before coming to the career opportunities, I would like to touch one more important thing. So what are the government interventions that I have mentioned? So government can intervene in the patents, and it can take your patent for a limited period of time. For example, the latest thing, COVID. So now, Mr. Let's say that AstraZeneca is having a patent on a vaccine which can treat COVID-19. Okay, and then what happens is, like, in India, they are not selling or marketing their product. Now what happens is, like, a company can go and then they can request for granting compulsory license. So they will request that because of this pandemic situations, we need a patent, or else we need an access to the vaccine to treat this COVID-19. So kindly please grant compulsory license for us. So for a limited number of time or a limited period of time, so that it is up to the controller and the government to grant, either to grant or not to grant the compulsory license. The interesting case is there already, so I will discuss in the next slides. So coming to the career opportunities that what we are having in pharmaceutical. So first thing, as I said, that patent IDF team. So each and every company, so forget about the pharmaceutical industries only. Think about the software industries, mechanical industries, automobile industries. Okay, each and every company will have their own IDF team. What do you mean by IDF? Idea generation team. So someone will get an idea. So in a R&D team, some people will get an idea, and then they want to go for the patent, but they don't know how to convert their idea into patented matter. So this is where the patent agents, or else the patent attorneys, or else the person who is having little bit experience in the patents will be help them in the patent IDF team. So this is a separate team each and every organization will have. Next one is patent searching teams. So this is an exclusive separate team. As I said, that prior art. Okay, there are different searches. There are different searchings are there. FTO searches is there, infringement searchings is there, prior art searches is there. So there are different category of searches that you can make. So for this, the technical people are very important. So as a pharmacist, and also as you are having experience in the patent, you can go for the patent searching team. So if you go for the patent searching teams, then as you are having the technical advancement, you can go with the prior art searches. So why exactly the technical people important here? Only the technical people will understand the key terms that are used in the patent. So Mr. A came up with one of the IDF, and he incorporated all the data that what he's having in his mind in that. So this is completely raw data. So you need to segregate depending upon the keywords, and then you need to start searching, and you need to deliver the searching reports as soon as possible. So each and every searching team will actively search all the patents globally available, and then they will come up with the search result. So here, one important crux is that it doesn't mean that you need to search and you need to say that, okay, this patent is already existed. You need to able to find out the gray areas where the patent is lacking. This is where you need to update to the IDF team, and then the IDF team will again go with the R&D team, and they will start their own research again. So this is the important part in the patent searching teams. So even here also, the pharmaceutical people, whosoever, not only pharmacy, as we are the as I'm dealing with the pharmacy, I'm telling that pharmaceutical people. Okay, if you go with the automobiles, the mechanical engineers and all, they will be fitting into this patent searchings. In all the pharmaceutical industries, the pharmaceutical background people will fit into this searching teams. Next is drafting team. So there will be again separate drafting team in the patents. So as I told that you need to draft the claims. The claims are heart of a patent. The how well you protect your claims, that strong your patent will be there. So here also, the creamy layer of the technological people are important in patent draftings. So if you're having experience in patents, and also if you're having any certification in the patents, along with your technical things, you can go with the patent drafting team. Mostly, like patent searching teams, after gaining some experiences, also they will go into the drafting team. Okay. And also there are different government patent cells. So this we don't know. Many people don't know that. Okay, each and every government universities and also different patent facilitation centers are there. Here also patent agents are very important. Okay. So for the patent agent, there is one more example called patent agent. So here you can act as a patent consultant also. Government of India conducts patent of agent exam. It is like for every 2 years or 3 years. Okay, it is not regularly on year-to-year basis. It depends. So it conducts the patent agent exam, and once you clear the patent agent exam, you will be get qualified as a patent agent, and it will give you a number, patent agent number. This number you can use for filing the patents. So each and every person cannot file a patent. Okay, you need to have your patent agent number to go for the e-filings. So here where patent agent plays a very important role. You can just be an independent consultant just by filing the patents. See, this is also one of the important area where you can concentrate actually. So once the patent agent notification comes, you can prepare for that and you can give a try to that. It is not that easy to qualify, but you need to keep on working hard. So in the patent, there are already patent agent notification have came lastly, and also it is closed, but this exam has been postponed. Any one of you have applied for the patent agent this year? Anyone? Fine. So the next year or the next to next year, there will be again patent agent notification. So I will inform to the S-Pharm education, and then this S-Pharm education can send you a notification, okay, on that when this patent agent notification comes out, and you can take the coaching and also you can try to crack that patent agent exam. So here a very important thing is that you need to have technical knowledge for to clarify the patent agent and also the legal knowledge. As I said that the Patent Act, you need to be clearly aware about the Patent Act, and also you need to learn about these sections and also what are the rules to, for the granting of patent and all. So then you can be an independent patent agent. That will be very relaxed job actually. So even I am a qualified patent agent. Along I am working with my organization National Law University as a patent facilitator. I am also an independent patent agent. I used to file patents not only from the pharmaceutical sector. Till date, I have filed 30 patents on mechanical, computers, and the electrical domains as well, along with the biotech and pharmaceuticals. That is one of the advantage for qualifying patent agent. If you are a patent agent, it doesn't mean that you should restrict to only pharmaceutical domain. You can even go with the any other domains. So there are many people who did pharmacy or else the MSc in chemistry and all, and they are working in different automobile sectors as well. You can switch your career after patent agent. So this is also one of the advantage of patent agent. Then next one is law firms. Many people have know that, okay, there are legal firms. So for example, there are separate corporate law firms are there. In the same way, there are patent law firms for there. There are topmost patent law firms which takes the technical people into their searching teams and then the drafting teams. Here also you can get opportunities to work with the law firms as well. Not only with the companies, you can work with the law firms, you can work with the government organizations, and also you can be an independent patent attorney. So these all are the advantages of being a patent attorney. So these are the career opportunities that you can explore. And if you have still more doubts, or else if you want any like a coaching or something else, you can approach S-Pharma education as well. Next slide, please. As I said that before, this is the design part. So I will take a 5-10 minutes to discuss about the designs. Yeah, I saw one question that, okay, the law colleges where they can provide distance education in law. So distance education in patent law, or else you want to do the distance education in law? Because law is 3 years course. I will address this answer in the last. Okay, you can just type me whether you want to go for the distance patent education or else distance law education. And as I said that in the patents, there is one more important thing is that compulsory licensing. So I said like there is an interesting case. Okay, Natco versus Bayer. There is an interesting case, Natco versus Bayer. So as you know that Natco Pharmaceuticals from the Hyderabad-based company, this is an into generic pharmaceuticals. So Bayer is having one patent on the anti-cancer product. So the cost of the each strip is around 1 lakh or something. Okay, 10 tablets cost around 1 lakh, and this is used to treat the blood cancer and some other advanced cancer stages. So what happens is here, Natco Pharmaceuticals filed for a compulsory license, stating that in India people cannot able to afford that product, and also the manufacturing of the product is very less in India. They are not making in India, and also this product is only available in metropolitan cities. One is availability, one is the price of the product, one, and also this is not making in India. On these three grounds, Natco Pharmaceutical filed a case and requested for compulsory license. What do you mean by compulsory license? This is the license given to that company, even they are having a patent. So they can go for the patent. They can start making of the patent even they are having compulsory license. Right? So Natco Pharmaceutical able to get the compulsory license because on the based on the three grounds. And also they said that they will supply this one for a reasonable amount of price. For example, as I said that the one strip costs around 1 lakh rupees and they started marketing for the 10,000. Obviously, because they're not investing in the R&D. So there is no expenses in the R&D and they can provide it for the 10,000 rupees, right, each strip. So this is the reason why compulsory licensing plays a key role. When there is an important what do you call that issue that should be addressed. For example, mostly in the pharmaceuticals, where many people are deprived to get that medicines. So these are related with the government interventions in India with related to the patents. Same way, now for example, if someone get a patent on the COVID related vaccine and they're not making in India and they couldn't able to make in India, like to supply each and everyone, they can go for the compulsory licensing. So these all are the provisions that are there in India. Fine. Next one, coming to the design protections. So designs, see, why I'm taking the design also along with the patent is that, am I audible? Design both hand to hand. So once you are a patent agent, you are a design agent as well. So you can go for the design patents also you can file. So that is the reason why I took the aesthetic appeals. Okay, the way how they look are okay, and also what do you call that? From the morning to evening, we can see different designs. Okay, the design of your laptop screen, the design of the mouse. So there are different designs only appealing to the eye. So these are so only one important thing is that can you hear me now? Am I audible? Fine. Yeah. So the designs. So designs is like as I said that okay, the patent agent can go for the design filings as well, along with the patent filings. So designs are mostly the aesthetic appeal of any object. So the designs can be protected in India under the Design Act 2020. Sorry, 2000. Okay, so the design should be only same like a patent. It should be new and original. That's it. You cannot copy a design and then you can go for the filing for the designs. Okay, and then it should not be disclosed in the public. Means like it should not be a prior art again. So same thing, same like a patent, it should not be a priorly available in elsewhere else in the world. Okay. So this is about the this can be go for the design protections in India, but the design protections in India are only for the 15 years, and then they cannot renew again. Okay, so only for the 15 years they can go for the filing of designs. So for example, see, now many people are listening to my session, and someone could have been like writing their notes, or in middle when they get bored, okay, they will draw something, right? Or in classes in the last pages, mostly in the last page we will draw something, right? So those things are like copyright protects, okay? And if you think that that design is very very good, and then you want to go for make that design and market it, okay, on any material, for example on the cloth, or else any hard surface or somewhere else, okay, you can go for the printing of that, then that comes under the designs. So once it is printed in a cloth, then this go for the designs. So that can be protected under Design Protection Act, right? So copyrights and designs are little bit similar, but there is a thin layer between the copyright and the design protections when coming in with the where it is exactly applying. So once you apply that copyrighted material or as a design material on any surface or as a material which can be made in an industry, so that can go for the design protections. So this can be filed, this can be protected for 15 years in India. Same way, these also should be filed according to the territorial in nature. If you want to file in India and protect in India, you need to file only in India, right? And also you need to go for your particular patent office. Okay, in Chennai, under the Chennai registry, you need to go, then you need to go for the Chennai patent office because you are from the southern part, right? Next slide, please. So this is how the design application looks like. See, the design applications are not that complicated like a patent applications. Say simple design, say simple product design, they have filed for the patent. Sorry, design patent. So these designs can be patented until unless this is not already existed elsewhere else, right? So design protections are very very easy. So not only the designs protected in this material, there are different designs in, for example, now coming to the COVID related things, okay? So the respiratory equipments, so these are having different designs, right? So these also can be get protected under Design Protections Act. Same way, masks and also different vehicles, okay, how the signal lights will be looked, and this also comes under this design protections. So this comes under the Design Protections Act. Next slide, please. So what exactly the advantages of design protections? The patents, we have seen what exactly the advantages of patent protections. One thing is that creativity, you can protect your creativities, and also it is aesthetic appeal, right? So it attracts the customers. So you need to protect your design to attract that. That is also one of the key role of the design protections. And also once you protect your thing, you are preventing others from copying. So this is also one of the right that gives from the protecting of your designs. And also it gives contribution to your return on investments. So once the design is protected, and if someone likes your designs and if they want to get license for your design, they will pay you royalty, okay? Or else you can sell your designs to someone else, and you are having a protected design for exclusively for 15 years. So this is the advantages of design protections in India. Next slide, please. So as I said that, so now we can look into role of patents and design during COVID-19, right? So as a pharmaceutical industry people, now you can see that, okay, so much of research and development happening, and also you can see so many news regarding this COVID related vaccines, and so much of investments, so much of fundings are happening in vaccine developments. So how many of you know about the Vaccines Alliance? Vaccine Alliance. So Vaccine Alliance is an organization, okay, where globally there will be donations to that Vaccine Alliance, and then they will start R&D in making the vaccines, okay, to treat different what do you call that issues like COVID related 19, AIDS, okay, or else Ebola, etc. And also they help for the least development countries to get access to the vaccines. Now so much of fundings, so many billions of money had been funded in Vaccine Alliance to come for the vaccines related with the COVID related vaccine. So now here, if you go for making and also getting a vaccine, you can protect your vaccines under patent. Then after getting your patent on your vaccines, you can go for the licensing, or else you only can manufacture your own vaccines. So this is one of the key role where the patent plays. Now for the COVID related thing, not only the vaccines that are developmental stage, okay, there are already existed vaccines. Anyone can tell that, okay, recently we are from last 2 3 months, okay, there is one drug, okay, which is keep on like we can see in the news that, okay, regarding the COVID related thing. Can anyone answer that? Okay, one drug, yeah, one is hydroxychloroquine, one more thing is there, which is like Gilead is having a patent on that. Yes, yes, exactly, remdesivir. So this drug, is a patented for the Ebola. Okay, so they, for the Ebola, they have come up with the research and development, and they have filed for the patent, and they got for that. But now the research is keep on going on, and they're telling that, okay, they can even treat the COVID. Because of this thing, this one patented drug got so much of attention, and almost all the industries are trying to get the license from that. And this company is also having a license and agreement with few of the generic companies. And you can see that recently in the news, even we can I saw that, okay, with the Dr. Reddy's and 5 more companies, one company from the what is it, Pakistan, and then Hetero Labs, and then Cipla, I think so. Okay, there are five companies. They got an exclusive license for the market making this drug. Okay, see, this is the what the value of the patent that they're having. So this is where the patent plays a very key role. So once you have a patent, every industry and all the companies will come behind you. Still you're having any issue? Okay, so in every industry and companies, okay, which are having a potential drug, they'll have very more acceptance in the market. Okay, each and every generic version of the companies will try to get this licensing from that particular company. So this is where the patents play a key role during the COVID. Okay, and coming to the design part, there is an interesting aspect. Okay, ISRO is having a design on the respiratory what do you call that device. So they have pledged their patent. Pledge their patent means like for the certain amount of time, they are not claiming the rights of their patent. They are saying that, okay, anyone can take the patented material and they can start manufacturing for a certain amount of time until and unless this one get addressed, this COVID. So this is also one of the important thing. Once you have patent, even you can donate your patents for a particular amount period of time also. So these are known as a patent pledgings. Nowadays, you can see most of the industries, okay, most of the companies, not only from the pharmaceutical companies, most of the software companies and all also, they are pledging their patents to address this COVID-19 vaccine, or to address this COVID-19 issues. So this is a different topic actually, pledging of the patents and then COVID-related vaccines, patents, and what are the issues that are related to that. So what can be probable issues and how government can interfere. These are all the different aspects, and this can, if someone is interested, we can take it in the other sessions as well. Next slide, please. This is like the different certification courses that in association with the Pharma we can provide actually to excel, to get jobs into different pharmaceutical domains. Okay, so what is Pharma, and then I can do is like we can give some certification courses on basic introduction on the patent searching. So how you can able to operate patent searching. So what are the things that you need to search, how you need to search, how you need to frame the keywords, etc. So the next one, we can give a certificate course on the drafting and the preparation of a patent application. So how you need to draft that. And even there is a certification course that we can give on the trademarks, introductions and searchings, how you can go with the trademark searchings. And if you want to go for the patent agent, then we can do the training for the patent agent as well. And the patent analytics, as I said, that there is a FIRA search, in the same way there is an FTO search, freedom to operate search, infringement analysis and all. And also patent landscape reports, patent what you call that FTO analysis and etc. Okay, this all comes under the patent analytics. Even these certification courses also with associated with the Pharma we can. And regarding these courses and also the time period and also the fee, etc., you can discuss directly with the Pharma educations, and then how exactly we can plan that depending upon the participants, we can plan accordingly. Next slide, please. Yeah, and then along with that, the other services that I can help with the not only with the students, there are some people who are working also in organizations, right? So if they have any patents, they want to go for the patent searchings only, and they want searching report. As a patent agent, I can help you them to get the patent searching reports as well. And also, if you have some inventions and you think that you need to go for the filing, we will help you in the drafting of the patents. And patent analytic reports we will give, design protections we will do it. And also, if someone is interested to come up with the startups, so nowadays there are many incentives for the startups. Even the fee for the filing of startup or the patents are very less. So if someone want to go with the startups, and I can facilitate for the startups also. As I'm a facilitator for the patents and designs for the startups under Government of India, I'm working. So trademark searchings and filings as well, I can provide for you. So if anyone is interested in these other services also, you can approach us. And also if you want any other particular sessions on patents or as on intellectual properties, not only with S-Pharma, or if you want to go with your organizations or something also in association with S-Pharma or something also, you can approach S-Pharma in your universities or somewhere else. Fine. If you have any questions, please do comment here. I'll address it. And don't think that, okay, either small question or very big question. Okay, whatever question you feel, okay, whatever doubts you're having, you please drop here. I'll try to answer. Okay, patent agent. Patent agent exam details, you can get in touch with the S-Pharma education. Okay, already the patent agent notification deadline have passed. Okay, so the next year, if there is a patent agent examination, so mostly the patent examination will happen for 2 years or 3 years. So it depends upon the demand of the patent agents. So if you want any patent agent things, the S-Pharma education will forward you this notification and all, and I will communicate to the S-Pharma. S-Pharma can forward the same. So we will give all the details regarding that. Okay, that agent training and all, if someone want to go for that. One more question I saw is like someone is asking about the patent law, distance. Am I audible? Yeah. So distance education in the patent laws, right? So there are universities, National Law University provides distance education in the IP law. So intellectual property law, this is for the 1 year and they charge around 35,000 or something. So this is for the 1 year and this can be in distance education as well. So this you can do it. And also NALSAR is also giving the exclusive only for the patent laws. So that is also for the distance education. So these are the two universities that are providing distance educations. And coming into the legal law thing, I prefer that don't go for the distance education for 3 years LLB. Okay, these degrees are waste. You need to crack into in very good universities like NALSAR, NLSAU, or IIT Kharagpur is giving. So in these universities, if you do your LLB, then only you will have in value. If you go only, yes. Can I continue?
Hello. Yes, sir.
Yes.
This is Shravan here.
Yes.
Sir, I was planning for one of the courses in NLSIU, that is Bangalore NLSIU.
Exactly. Yeah, I am working there only. Yes, please. Yeah.
Yeah, masters in business law.
Okay. Good.
Yeah. Can I know about what is masters in business law and how future how can I have a future in that master in business law?
See, masters in business law, it is not like that of an law thing. Okay, complete law. So this is first thing is like this is a distance education. So there are like hundreds of people will enroll for this masters of business law in NLSU every year. And this is not a this is a good course. Okay, you will get introduced to the different business aspects. Okay, contract laws, not only intellectual property rights. You will get into touch with the contract laws and also different laws in the how to operate a business. And also environmental issues and also contracts, company law, etc., taxations and all. So this is a good thing, but only one thing is that you need to be very active to attend the classes. Then you can gain the knowledge. And coming to the job opportunities after MBL, they won't assure you any jobs. Okay, it is all up to you how you crack or get the jobs.
Okay. Like classes will be like weekends or regular sessions?
Classes will be in the weekends and also in the alternate. Okay, so Saturday and Sunday classes will be there. So for every alternate
Okay.
Saturday and Sundays, it will be there.
Yeah, okay. I'm in Bangalore, so I can attend it.
Yeah,
So I
yeah.
wanted to.
Okay, good, good. Yeah, if you're in Bangalore, you can attend, and you can even meet me also. I will be in that university only. So even you
Yeah,
can come
okay.
to the patent cell and you can meet me there.
Yeah, okay, sure. Thank you.
Yes. Any other? One more question. I saw that are patent cases filed in civil or criminal courts, or there are separate authorities to deal with the cases? Okay. So as I said that first is IPAB, Intellectual Property Appellate Board. Okay, the patent cases means like there are two different things. One is infringement issues, or else the other one is that you are not satisfied with the order given by the examiner. Okay, when you are going for the filing of patents and all, and the examiner couldn't able to grant you patent, then you need to challenge that. To challenge those things, you need to go for the IPAB, Intellectual Property Appellate Board. And if IPAB is also not able to address, then you can go for the High Court and then Supreme Court. Then coming to the infringement issues, wherever it is having, it will go for the civil courts. So first thing is like the basic district court it will go, not even the civil court, only basic district court it will go. And these all are the civil in nature. So intellectual property right issues are always civil, not the criminal cases. Am I clear? Next question is after B Form C, where can I go for the patent agent course? So there are many organizations that give for the patent agent. Even the S Pharma, we are planning to go for the training for patent agent itself. You can directly contact S Pharma Education itself for patent agent course if you want to, if you are seriously looking to crack the patent agent. And also you can, or else you can prepare by yourself only, but the guidance is very, very important. So you can approach like S Pharma Education. I think S Pharma Education can guide you for that. Am I clear? Balakrishna. Yes. Any other questions, please? You can unmute yourself and you can ask as well. Yeah, yeah. Okay, trademark. Yeah. So I observed that in trade names there is R, which is someplace in the beginning of the name or somewhere. What is the reason behind that? Good question. So coming to the trademarks, so trademark registrations are not mandatory. Okay. So either you can go for the registration of your trademarks, or else you need not to go for the registration of trademarks. But registration of trademarks is very important to show that your trademark is registered and protected under Trademark Act. So the symbol R says that this trademark is already filed and protected, and trademark protection had been granted. As a patent certificate and design certificate, you also received a trademark registered certificate for your particular trademark. That is the reason why they put R. And if someone is putting TM, it is a trademark, they have applied for the trademark protections until, or they may not get the trademark, still it is in the examination process. That is the reason why they may keep TM. So TM means that is capable of getting trademark registrations, but till now it didn't get trademark registration, maybe in the examination process. R means it is already registered as a trademark. Am I clear, sir? Shiv Kumar, sir. Dr. Shiv Kumar. How to get funding to apply for patent, as it requires a lot of money in the whole process? Good question. Excellent. See, if you are a startup, if you are having a startup, then there are what you call MSMEs providing loans for the patent filings, but you need to go with the particular patent facilitator or someone else who have registered under MSME. For example, there are patent facilitators under Government of India. Okay, under that list, you need to go for the patent filing. Then you may get the funding, but funding only you will get for the what are the expenses that you have incurred. That's it. Okay, it doesn't mean that to conduct your research and everything. And there are some universities, sorry, there are some patent facilitation centers also. Even we also from the national law universities, we provide pro bono, means like free services for patents. For yearly 2-3 patents, we will go for the free filing, but examination fee should be bear by the applicant itself. Okay, no one will take care of examination fee, so government fees will be there, that should be taken care by them. But the drafting of the patent and then the searchings of the patent, clearance reports, etc., will be taken care by this patent facilitators as well. Am I clear, ma'am?
Sir, this is Sivakumar.
And if you want to go for the funding of patent, and if you're having a patent in thing, even you can approach me as well. Okay, even I am the patent facilitator, and also you can either you can write directly to the Pharma Educations and they can connect to me. So there will be no issues on that. So I can guide you then how you can go for the patent filings and use that. Yeah, someone is asking something.
Yeah, Yeah, this is Sivakumar. You answered about the difference between R and TM. I understood that.
Yes, yes, okay.
The difference is in some trademarks, I am seeing the letter R, registration, right?
Yes.
That is
yes,
the
sir.
beginning of the word,
Hmm.
or in some letters it is at the end.
Okay. So it should be at the end actually. See, one thing, sir. The first thing is that it is not mandatory according to the Trademark Act to put R.
Okay.
It is not at all mandatory according to the Trademark Act. The Trademark Act helps to get you the trademark. Okay, it says that okay, these are the things in which cannot be get trademarked, which can be get trademarked. So once you get
Okay.
the trademark, it is up to that person who where he is keeping that, okay, to show that, okay, to publicly show that okay, this is a registered trademark. Mostly all the people will keep at the end of that. So end of the trademark, they will put R in the circle to show that okay, this is already a trademark product or the trademark brand name. So kindly please don't copy. I am warning you that if you copy, we will go for the trademark infringement suit. That is the
Okay.
reason why they.
Okay. Thank you.
Yes. Anything else? One more question once again. If a person develops a new product under company's R&D department, which company give him a share in the patent rights in general? Okay. So I will take into two different ways here. So one, there are many people who are already like pursuing the course and they are into the research and development or else in your institutions, right? So, and some people are working in organizations. Now, let's take it now in the both the same thing happens. One thing is that a person or an employee develops a product under company. It is clearly written that under a company. So here company is providing you all the funds and facilities. You are using all the laboratory equipments and it is paying you to do that research and development, right? So obviously the person who is investing in you, they will have all the rights in that. Okay, they will give you right as an applicant. Rest of the thing is that it depends upon the company to company. Okay, this is internal agreement between the company to company. If company says that I will give you an equal share on that, it is well and good. But most of the companies will go for the patents on their own. So patent will be on that company itself. If you want to develop on your own, you need to separately come up with your own R&D setup outside, and then you need to develop and you need to file. You are using all the what you call that research and development facilities in the institutions or else in the company, and then you want to go for the patents, that is not at all fair, and they will file a case itself. Okay, it's all there. It will be in the agreement itself. It depends upon the company to company, but in general, the company will have all the rights. You will have only the right as an inventor. Your name will be as an inventor. Am I clear?
Guys, I'm Umashankar. I take care of administration of this Pharma. The reason of being conducting this webinar is it's a completely different field other than pharmacy. I'm really inspired with the journey of Mr.Jnana Teja. He started B Pharmacy, M Pharmacy, and then going back to IIT Kharagpur, completing his law there. So it's a really incredible journey. So people doesn't know much awareness about this career opportunities, particularly in law and patents. So make use of this maximum webinar, ask your questions. If you have any specific questions, please ask that. And those who registered for this webinar, they'll be getting what we call booklets, e-books we'll be giving, and we'll be sending the complete this course details also. So don't worry about those things. Make utilization of this time. We'll be extending this question and answer session for another 15 minutes. Ask your questions, and we have students from third year to even company heads also are there in this. So please use that. Any question is not a silly question. Please ask all the questions. And if you want to choose your career particularly related to law, this is the right time for this final year or maybe M.Pharmacy students. So you can ask the questions.
Any question, anything, if you want to ask, you can. Okay. One more thing I need to tell to students that, okay, if you're interested in the patent searchings and this domain, okay, and you can do some certificate courses either with S-Pharma or somewhere else, and we can help you with getting internships as well. Okay, you can approach me for the internships. I can guide you for that as well. So mostly if you do with the S-Pharma education, this will be an added advantage that, okay, we can provide you even internships with the law firms as well in online or else offline. So you can get practical touch with this, how the law firms or industries works. Any more questions?
Yes, Dr. Shiva. After the seminar, I mean, after this webinar, you'll be getting all the details about the speaker, our courses, and your e-certificate. So all these things will be mailed to you. So maybe probably by evening, we'll be sending your booklets, and by tomorrow evening, you'll be getting the certificate.
So this is my LinkedIn name. Okay, you can follow there. My complete name is Jnana Teja Bandi, so you can search in the LinkedIn for that. I think S Pharma will provide you all the details. So mobile number, and if anything, if you want, you can contact S Pharma Education as well. So you have completed Pharma analysis, and I'm pursuing LLB. May I know from which college you are pursuing your LLB? And is it in the distance mode or else in the regular mode? Which college, please? College name? Okay. So you're pursuing your LLB in Kakinada. Fine. Normally, there will be basic course in patent law, right? In the LLB. So you didn't cover anything. Which year are you now? First year, fine. So this is 3 years or a 5-year LLB? Fine, good. So in mostly in the third year or something, these colleges, okay, they have their own separate subject on the patent law, so you will get introduced to that. I don't think again separately you can go for the patent law. Okay, so if you want to go in the draft, you want to learn about the draftings and searchings, etc. Okay, procedural issues and also technical issues, then you can do the courses. Okay, that what S Pharma is providing and all. But apart from that, like you are already in the LLB thing, so you need not to go for any other again patent law course. So if you want to learn the patent drafting, etc., then you can learn those things. And also from now you need to concentrate in the internships as well. So you need to approach, already you are having M-Pharma, so technical knowledge is there in LLB from Canada, so you can try to get into some law firms. So try to approach law firms to get your internships done, then you will get your practical experience. My only advice is that if anyone want to go for the LLB, don't go for the distance education mode, and also don't go only for the topmost law schools. Okay, so then only you will have an added advantage there. Just for the namesake, please kindly don't do LLBs. Yeah, there is no distance offering. See, there is no distance offering in LLB, sir. Same thing like M-Pharma. So there is no particular distance education in M-Pharma. But nowadays we can see in the market that, okay, you need not to go for the universities or colleges, and you can manage that attendance, right? In few colleges. So same way you can manage this, in the same way you can manage for the LLB, but that doesn't contribute any value to your for your career as well. So my genuine and answer is that, okay, don't go for the distance education at all for the LLBs. You need to invest your time and energy to success. What is it? I didn't listen. I didn't hear about that college actually. I didn't hear that college name. See, yeah. See, I will tell you the topmost law college, okay, topmost law universities. One is the rank, according to even recent rankings, National Law University, Bangalore is the topmost law firm. Okay, sorry, topmost law college in India itself. The next one is Nalsar in Hyderabad. And then you can try in the universities. Okay, Osmania University is fine, Andhra Universities is fine. The universities in particular state, that is also fine. There is no patent college in India exclusively. Okay, so there are some colleges which offers honors in intellectual property rights. For example, IIT Kharagpur, from which I pursued my LLB. So this is into LLB, but mostly concentrates in the IPR, honors in intellectual property rights law course. So for this, you need to give your entrance examination will be there. So you need to crack that, and then you need to give interviews, group discussions, etc. And then you can. Pharma D jobs, you can ask Mr. Umas Shankar regarding that. I think he can keep one more seminar on pharma D jobs opportunities in India. I think so. That will be good. Anything
So I can
particular
see
to
some of the college faculty also attending this one, HODs and principals also. So in related to your research work, maybe patents, if you want to take for the PhD work, what you have done, this is the right opportunity. He can guide you the process and all. Any article publications, what you have done, any research work, all those things you can ask, sir.
Yeah, or else you can contact me with you can contact S Pharma, they will connect me, or else you can mail me to my mail ID. Okay, this is my mail ID, National Law University mail ID, Jnana Teja @ LinkedIn. I think this is my LinkedIn. Okay, you can search Jnana Teja. Jnana Teja Vandi, you can get in my LinkedIn.
All right, we'll extend it for another 5 minutes. So now time is 1 o'clock. We'll close it by 1:05. So still, if you have any questions, you can ask.
Any questions regarding anyone are interested in startups? Anyone interested to come up with the startups? How many of you are not interested to do a core pharmaceutical jobs in this? Salary and startup. Salary for what and for the startup? I didn't get you, sir. Salary for what? Salary for the patent professionals, it depends upon the organization to organization and law firm to law firm. So if you are into topmost law firms and topmost what you call that patent in-house patent teams, you will get around in the patent teams you will get around 5 lakh or 6 lakh. Okay, it will be, and if you clear the patent agent exam as well, depending on that. Okay, so you'll get into 6 lakh or something around that. And coming to the law firms, there are law firms which pays you very less. Okay, 20,000, and there are law firms which pays you 80,000, 1 lakh as well. So it depends upon your knowledge. Technical knowledge is very, very important for that. And the added advantage working with the law firms is that you will get an experience with many more cases actually. So once you gain experience, then there is no limit for you. In the patent field, not like in pharmaceutical. In pharmaceutical industries, mostly I can see that okay, it starts from the 8,000 or something. Correct me if I'm wrong. Okay, so mostly I will see like that, and also the growth will be very, very less. I mean, like in the salary hikes. Okay, but when you come into the patent thing, what happens is like patent thing. What happens is like once you get the experience, then once you are gaining the experiences, the hike will be increased. Okay, you will get even the 100% hike as well. So it is completely depend upon your knowledge and the technical skills that you are having. What kind of startup? So what kind of startup means like it depends upon your interests. So that is the what kind of startup that you need to start. So it depends upon each and every person. Okay, someone would like to start something related with the pharmaceutical active ingredients or something, or else the pharmaceutical trainings or something. So it depends upon each and everything. Okay, and also marketing things. So marketing related startups. So you need to get a product which is expired patent, and then you want to manufacture that. Okay, so such kind of startups that you can concentrate. Sir, can we file a herbal research patent for free? Can we, as a patent filing is charging 50,000. Patent filing government fee is not a 50,000. You can connect with S Pharma, or else you can mail me directly. Okay, I think you are having my mail ID as well, or else you can mail to S Pharma Educations and you can connect me. We can discuss about that patent, herbal patent related thing. Am I clear? Yeah. So for the patent filing is charges different actually. So we can discuss these things. Okay. You can directly contact me, or else you can come with touch with Mr. S Pharma Education as well. Good shifting. Thinking to shift career opportunity is good. After COVID, any career opportunity regarding startup ideas. See, startup ideas is depending upon that your ideas. So I cannot nurture my ideas into your mind, and then I cannot say that okay, go with this startup. So startup is completely like your baby. You should come up with your own ideas. So you need to look into the gray areas that what they are having now. So COVID-19 related, you're telling. Okay, one thing is the respiratory tract related things, and then the one thing is the mask related things. Okay, there are many things. related not only with the COVID. There are very interesting patents that have been filed recently. One is the sterilization for the currency notes. Okay, these are the BTech people who have filed for a patent regarding that. So this they can come up with a startup for that. This is also relating to the COVID-19. Right? So such things we need to discuss. You need to think what is the problem and how you can address it with your startup idea. That's how you need to nurture your startup ideas. If you want separate session on startups, you can take one more startup sessions as well. So what are the requirements to start a startup? So how to get the certifications? What are the MSMEs? How MSMEs are contributing for the startups, etc. Also. Yeah, I am a BPharm student, so I don't have that much idea about what to do after BPharm. So many of our seniors are doing MBA. Many are doing M-Pharmacy. Which course will be helpful for students after BPharmacy? See, which course will be helpful after BPharmacy is completely your depending upon your interest. If your interests are into the marketing side, you can go for the MBA. If you want to pursue and if you are good in the technical things and if you want to go with the R&Ds and all, research completely in the pharmaceuticals, then you can go for the M-Pharmacy in the particular interested specialization and then you can move for that. Or else if you want to explore the patents and all, you can move for the patent domain. So you need to think about your interests. Each and every course is each and every path is excellent only. You can success in everything. So after doing M-Pharmacy, there are many successful people. There are many failure people as well. In MBA, same thing, success and failure is there. After LLB, success and failure will be there. So it's all depend upon your interest.